The case management form, Your Worships, and Ma'am, you will notice that whilst it has been completed as far as possible, the defence have not been prepared to outline their defence.
Mr Edwards,
Ma'am.
We note that you've written in paragraph 8.4 of the form that the Crown is put to strict proof of its case and any further details in respect of the issues is governed by legal professional privilege. Could you please explain this?
Certainly, Ma'am. Your legal advisor will be aware of the case of the Epping Justices matter, which took place in 2011, Ma'am. And as a result of that surprising ruling by the High Court, there will be cases where the defence cannot fully address the issues, as to do so would be tantamount to him revealing his own defence and incriminating himself, which of course she's not obliged to do. That at least is still good law according to the recent case of Rochford.
Thank you. Miss Riddle, could you please advise us on this?
Well, yes, Your Worships, I have prepared some notes on this, in fact. And it is true that the Epping Magistrates case is authority for suggesting that matters raised in the case management form can be allowable as admissible hearsay evidence and could, on rare occasions, assist the case for the Crown. However, I would suggest that the parties are still bound by the criminal procedure rules and the Consolidated Criminal Practice Direction, which confirms that the parties must assist the court in the early identification of the real issues in the case and of the needs of witnesses. The recent cases suggest that whilst the completion of a defence statement, or as in this case, the case management form, does not require the defence to reveal privileged information, the defence must still disclose what is going to happen at the trial.
Can the defence really state that they put the prosecution to strict proof? I thought the Chorley Justice's case, which is regularly quoted in this court, had put a stop to that.
Well, ma'am, Chorley Justices and the other cases on the point are authority for saying that it is no longer possible for there to be so-called ambushes at a trial. This means that it would be possible for the defence to state that the defendant does not admit the offence, or the relevant part of it, as the case may be, and calls for the Crown to prove it. But the defendant must also say that he advances no positive case, because if he's going to advance a positive case, that must appear in the form.
With respect, ma'am, I do not agree with your learned legal advisor and wonder what her authority is for that proposition.
Well, in fact, it comes from a case quoted by Mr Edwards himself, R versus Gavin Rochford, 2010. Although that case was referring to a defence statement, by analogy, and in line with the judgment in the Epping Magistrates case, it must clearly cover the completion of the case management form.
Well, ma'am, I fear that we must agree to disagree on this point, and I'm unable to assist the court further to give any more details, and maintain that to do such and give such details are covered by legal professional privilege.
Mr Edwards, though, I'm sure you won't object if we explain to your client the consequences of relying on privilege? Miss Pointer, would you like to stand, please? As you've heard, there's been some technical discussions going on, and perhaps I'll try and explain to you in non-legalistic terms what these mean. All parties in criminal cases, and that includes you, have a duty to assist the court in active case management. And what that really means is that the court, with the help of all the parties, must discover what the real issues are in the case, and that has to be done at this hearing. Your solicitor's quite right in saying that you can rely on privilege in certain cases, and we'll go no further into looking at the reasons behind that. However, it would be extremely unfair to you if we don't point out the potential pitfalls when criminal procedure rules are not followed, fully complied with. For example, the case may be much longer than necessary. Witnesses are told to attend court with all the inconveniences that causes them, without them actually being needed. And if the case is adjourned at any stage to deal with points that have not been brought up previously, the cost of the proceedings will increase to a great extent. And normally, if you're convicted, then you would be expected to pay the costs of the proceedings, which could, and very often does, amount to thousands of pounds. When we retired earlier on another matter, our legal advisor drew the attention to the Adult Criminal Case Management Framework, which is referred to in Stone's Justice's Manual, and states, only witnesses who are relevant to a real disputed issue should be required to attend the trial. Each party should expect to be required to justify the attendance of each and every witness by explicit reference to a real disputed issue. So bearing that in mind, we will now go through the various witnesses and explore whether they are needed to give evidence, and if so, how long any cross-examination may take. Thank you.